Good morning, and thank you for joining the RTA's webinar as we recap the rental law changes of 2024 and we focus on the questions we have received from customers on these changes. Before we start, we'd like to acknowledge the traditional owners on the land on which we meet today and pay our respects to elders past, present, and emerging. Now, today's recording has been done due to some technical issues with our previous live recording. And today I'd like to introduce my colleague and myself who will be hosting today's webinar. My name is Lynn Smith and I'm a Senior Advisor in the Education team with the RTA and have over 38 years experience with the residential tenancy laws. My colleague joining me today is Mark Fiddler. Mark's been with the RTA for over 19 years and brings a wealth of knowledge, having worked in our customer support area and our bond management areas before joining our education team. Good morning, Mark, and welcome and thank you for joining me.
Thanks, Lynn, and good morning to you.
Before we start, the role of the RTA is to administer Queensland's rental laws. We do this through many services the RTA has, such as our contact centre, bond management, free dispute resolution services, and our compliance and enforcement. It is important to note that we do not write the laws. Our role is here to help you and everyone in the rental sector understand the laws and the rights and responsibilities under these laws. There has been a number of changes to legislation over recent years, which started back in with the Housing Legislation Amendment Act in 2021. Earlier this year, a bill was passed in Parliament on the 23rd of May and saw changes implemented in stages. First on assent on the 6th of June, and then we had part 1 of proclamation on the 30th of September. Next year, there will be a second part, which will commence on the 1st of May 2025. I'm now just going to hand over to Mark and he's going to provide an overview of the main changes this year, which are now law. We will provide a brief explanation on each of the changes, and at the end of each topic, we will have a series of questions that we've received from the rental sector about these topics, which we will answer to help clarify these changes before moving on to the next topic. If you are looking for more detailed information on all the changes, please jump on our website. Again, our focus today is to answer the questions we've heard from the rental sector over the past months. So over to you, Mark, and I'll be back soon.
Thanks, Lynn. First, we're going to have a look about the changes in regards to rent. So properties must be advertised at a fixed price, and a person cannot solicit, invite, nor accept an offer of higher rent. So if you advertise a property at, let's say, $500 a week, the tenant that is looking to rent that property can't offer a higher rent amount for the term of the agreement. Also, maximum rent amounts to be taken at the start of the tenancy for a fixed term agreement are 1 month. For a periodic tenancy, a rooming agreement or a movable dwelling agreement, the maximum rent in advance amounts are 2 weeks. Even if a tenant offers to pay more, the manager or owner cannot accept any more rent than the allowable amount. Now, it is important to note with this one that once the tenancy has started, a tenant can pay additional amounts and get themselves further in advance. But at the start of the tenancy, those fixed amounts are set. So in regards to rent payments, there has been some change here. So managing party must offer 2 ways to pay rent, one of which will not incur more than usual bank costs and is reasonably available. There are a couple of commonly asked questions on this topic, and we'll address them shortly. Other changes around rent are in the rent increase space, and you'd all be aware that when it comes to rent increases, the rent cannot be increased less than 12 months after the last increase at the premises. Now, this is unless you are an exempt lessor, and I'll talk a little bit more about that in a moment. The tenancy agreement must include the date of the last rent increase, and if the tenant requests evidence, it must be provided within 14 days of the request from the tenant. Now, exceptions here include exempt lessors or where properties are being rented for the first time, and if the property has been purchased and the new owner or property manager does not have the information about a previous rent increase. If you are an exempt lessor, the 12-month rent increase provisions do not apply, and you do not need to include the last rent date on a tenancy agreement, nor provide evidence of the increases.
Thanks, Mark. So let's have a look at the questions. If The owner changes mid-tenancy. Can rent be increased less than 12 months since the last increase?
No, Lynn, it can't. So regardless of whether there's a change of owner or property manager or a tenant at the premises within the 12-month period, you cannot increase the rent earlier than 12 months since the last increase.
Our next one is if renovations are done during the tenancy or between tenancies, can the owner or the manager increase the rent before that 12-month period is up?
Yeah, another good question. And in a word, the answer is no. But the thing here is the Act does provide for the property manager or owner to make an application to QCAT, that's the Queensland Civil and Administrative Tribunal, because they would suffer undue hardship if they were not able to increase the rent. So a Form 16 dispute request must be lodged with the RTA, and we will issue a notice of unresolved dispute to enable the property manager or owner to make an application to the tribunal and have the matter heard.
For rent increases, what is an exempt lessor?
Yeah, so I mentioned a moment ago that we would touch on this. So if the lessor receives funding under the Housing Act 2003 or the Community Services Act 2007, then they might be considered exempt. Now, the RTA cannot determine if you are an exempt lessor, but most community housing organisations are likely to be exempt. We do encourage organisations to seek their own advice to determine whether they are exempt or not. And just another quick note here, if you do not receive funding under the two acts that I mentioned, then you would not be exempt, and there's no capacity under the Act to be made or considered to be exempt.
Now, is a money order an allowable second way in which a tenant can be asked rent? And I know that money orders were never really in that approved list from previous legislation, was it, Mark?
No, well, that's exactly right. And I think the money order now is up around $13 or $14 to actually obtain. So the Act actually states now that two ways must be offered, one of which does not compel the tenant to incur more than the normal bank costs and is reasonably available. So there's no longer a list of approved ways as there was prior to this change to pay rent. But as you mentioned, money order was never approved way prior to the changes. So it's probably not considered to be a reasonable way to provide or provide as a second option.
Because obviously the cost for the money order is probably a little bit higher than what a normal bank cost
That you,
may
yeah,
actually be.
exactly. Correct. Yep.
Now, do I have to provide evidence on the last date the rent was increased? And what happens if I have purchased the property and I do not know when the last rent increase was?
Yeah. So if a tenant requests proof or written proof of the last increase, you have 14 days to provide the evidence. Now, this might be in form of a suitably depersonalised rent ledger or a previous tenancy agreement or something like that. But if the property's recently been purchased and the new owner or the property manager doesn't have that information around when that last increase was, then the requirement to provide a date on the tenancy agreement or provide evidence does not apply. It's probably still a really good idea to respond to the tenant and explain to them why you can't provide it. And that would be that you've only just purchased it and it's considered then that you've met your obligation there. It might be considered that you've met your obligation.
And again, that really good communication with in that sort of a situation.
Yeah, absolutely.
Over to you, Mark, to talk about the rental bond side of things.
Yeah, thanks, Lynn. So we're going to have a look at the changes in relation to rental bonds. So the first change is in relation to the maximum bond amount that you can take, and it is now 4 times the weekly rent, regardless of the amount of rent payable. So previously, if the rent was $701 or more, you could negotiate with your tenant as to how much bond you would hold. But this is no longer relevant, and now it's a maximum of 4 weeks' rent. So tenants who have bonds held by the RTA that will exceed the maximum bond allowable when they next renew their agreement will be able to request a refund by using our newly created excess bond refund for tenants form 4B. The other change here is in relation to bond claims or disputes. So when making a claim or disputing a bond, the property manager or owner must provide the tenant with supporting evidence within 14 days of lodging that claim or lodging the dispute. There are transition periods relating to this change. So if a bond was lodged prior to the 30th of September 2024, and is claimed prior to the 30th of September 2025, then this provision will not apply. For bonds lodged after the 30th of September, when a claim is made, the evidence will need to be provided within 14 days. So just to be clear there, so for most claims at the moment, the likelihood is that those bonds will have been lodged prior to the 30th of September 2024. So this evidence provision won't apply. But for all of your tenancies that are that started after the 30th of September 2024, so at the time that you make that claim on that bond, and it might be 6 or 12 months down the track, so you will have a little bit of time to work out how you're going to provide that evidence and get that to the tenant within 14 days.
But as we know too, Mark, that really good communication, like even if there is a claim, talking to the tenant and letting them know what that claim might be, um, showing the evidence, sharing photos, the exit report and things like that is one way to try and avoid a dispute happening in the first place.
Yeah, exactly right. And that conversation and being able to work things out between yourselves, and that's the quickest way to get your bond back, a fully agreed form, and get it into us. So the other changes in regards to rental bonds here. So boarders and lodgers are not covered by the Residential Tenancies and Rooming Accommodation Act. But if a bond is paid in this situation, it must be lodged with the Residential Tenancies Authority. Now, this also extends to include where the owner lives on site and rents out less than 3 rooms in the property. There have been some changes to the processing for refunding bonds involving commercial bond suppliers. And if a bond dispute is unresolved through our dispute resolution and the matter progresses to the tribunal, so that's to QCAT, if the tribunal dismisses the matter or the matter is withdrawn, then the RTA can release the bond as per the original request.
Great, thanks, Mark. So our questions are, what is deemed to be evidence for bond claim? Do I need to provide an invoice?
Yeah, it's a good question. Now, and it's the Act itself doesn't define what supporting evidence is. However, it does offer some examples of acceptable evidence, and it mentions things such as receipts, repair quotes, or records of unpaid rent. Now, the one thing you'll notice with these examples is that they all involve a monetary amount or a dollar figure. So as much as there's no definition, it would be reasonable to expect the tenant be provided with an idea of the cost of the claim.
And what happens if I'm in a remote area and it's hard to get a quote from a tradesperson? This is probably something that we've actually heard, not necessarily always in a remote area, but throughout Queensland.
Yeah, and obviously the last few years we understand the difficulty around getting hold of tradespeople. So this particular question was actually raised at one of our sessions in regional Queensland, and before we had an opportunity to provide an answer, one of the property managers in the room suggested that she takes photos of the damage and emails them to her tradespeople and requests a quote based on the photographic evidence. Now, it's important to note here that this requirement only applies where your bond claims for bonds lodged after the 30th of September 2024. Now, as I mentioned earlier, we'd expect that most refunds processed in the next period of time will be for bonds lodged prior to the 30th of September 2024. So this provision won't apply. So you will have some time to work out how you're going to meet these requirements.
And obviously to work with tradespeople to work out what their timeframes might be and so forth.
Absolutely.
So what happens to a bond on a periodic tenancy that exceeds 4 weeks' rent? So you mentioned the maximum now is 4 times the weekly rental amount, and if it exceeds that 4 times the weekly rental amount on a periodic agreement.
Yeah, so to look at this, we really need to look at the legislation. So the legislation states that tenants that have bonds that are greater than 4 weeks' rent can request a refund of the excess amount if they renew their tenancy. So let's say, for example, a tenant's currently paying $750 per week, but they'd negotiated a bond amount of $5,000. So we know that that's over the 4 weeks' rent. Now, if they renew, for example, let's say on the 15th of December, and the rent increases to $800, then the maximum bond allowed would be $3,200. But we're already holding $5,000. So the tenant in that situation could request the $1,800 be returned to them. Now, a periodic tenant is unlikely to have a renewal, so how can they request a refund? Now, the legislation doesn't really provide, but we would encourage the tenant and the agent to work together and submit an agreed do not finalise refund request. Now, if the agent doesn't cooperate, then the tenant can submit a request and we will issue a notice of claim, and the matter can go through dispute and off to the tribunal if needed. But again, as you mentioned, we'd encourage that communication and the parties to work together to resolve these matters.
So just clarifying the 14 days for the notice of claim process for the RTA versus that 14 days to provide evidence. What happens if you cannot provide the evidence to the tenant within the 14 days? So we know that's two separate processes, isn't it, Mark?
Yeah, it is. So if a refund request is made and we don't have all the signatures from all the parties, then a notice of claim is issued to the parties we don't have signatures from. So they then have 14 days to agree or disagree with the claim made. So that's a legislative process and it hasn't changed. If we don't get a response from in regards to the notice of claim, then effectively we pay the bond out as per the original claim. If a property manager or owner makes a claim or disputes a tenant's claim, then they will have 14 days from when they submit the claim or submit the dispute to provide evidence of the claim to the tenant. So the two processes are separate. So if they don't provide that evidence, it won't stop us continuing with the dispute process. And there are offence provisions around them not providing that evidence. So something to be conscious of there, but it won't hold up the dispute process and it doesn't change how we'll continue to work through that bond refund.
And how does the property manager know that a tenant's claimed that excess amount over the maximum 4-week bond period, that maximum 4-week bond amount?
Yeah, so good question. So if a tenant does request a refund of their excess bond, we will make the payment if the form is correctly filled out. So the form asks for a new tenancy start date, so that indicates the renewal, and it also asks for the new rent amount. And we will also look to ensure that they're not claiming more than the allowed amount. So we need to ensure that 4 weeks of the new rent amount is left with the RTA. So if all of those things are right, then we will make the payment. So there is no notice of claim process with the Form 4B. But once we have made the payment, the RTA will issue new acknowledgement of rental bond notices to all parties, including the property manager or owner. So that's when they will be notified of the balance that we're holding, and that will obviously suggest to them that that payment's been made.
Okay, let's have a talk about reletting costs. And we know that we're probably going to spend a little bit of time in this space just to clarify what these new rules are because they are quite different based on what people would know in the sector on the previous way and the previous charges. So over to you, Mark.
Thanks, Lynn. So yeah, look, in a break lease situation or where an agreement ends early, the word reasonable costs has been replaced with reletting costs. And the changes outline maximum costs, and these are based on the remaining time on the agreement and whether the fixed term agreement is less than or greater than a 3-year term. If the term's less than 3 years, the reletting cost is an amount equal to the rent payable for the period between the tenant vacating and the date of the new agreement starting, or it's calculated based on the percentage of the fixed term that has expired. Now, the key here, and it's important to understand that these new provisions only apply to tenancies that started or were renewed after the 30th of September 2024. So looking at a little bit of this information in more detail. So you can see here how the reletting cost is calculated for agreements up to 3 years. So on the page there, you can see the scale there, so the schedule. So it shows that if less than 25% of the agreement has expired, then the tenant can be liable for 4 weeks' rent as the reletting cost. And then a sliding scale, so between 25% and less than 50%, the tenant can be liable for 3 weeks. If 50% of the agreement to less than 75% of the agreement has expired, then the tenant can be responsible for 2 weeks. And then finally, in that last third of the agreement, or where more than 75% of the agreement has expired, then the tenant can be liable for 1 week's rent. Now, the key here is that if you rent out the premises earlier than what the potential claim as per the scheduled amount is, then the reletting cost is the lesser of the two amounts. It's not both. Now, our website does have a reletting calculator, and an example of this is shown on the screen. Now, this won't provide a dollar amount, but it does state the week's rent you can claim. And this again is only applying to agreements entered into or renewed after the 30th of September 2024. If a tenant breaks an agreement that started prior to the 30th of September 2024, this calculator cannot be used to determine costs.
And likewise too, Mark, isn't it? If an agreement starts prior to the 3rd of September and it has that term in it that they can be charged reasonable costs, it's business as usual as such in relation to a let fee / maybe some advertising and maybe the compensation for loss of rent. So it's just clarifying the key here is that when that tenancy agreement starts.
Yeah, exactly right. And as per the question that's up there on the screen, so that agreement, it started prior to the 30th of September 2024. Tenant's broken their lease. So the claim that can be made in that situation includes loss of rent until a new tenant's found, plus advertising, plus the reletting fee, which is the fee that the property owner pays to an agency or a manager for reletting the property or the room.
Sorry, I've jumped the gun there, but yes, I know it is one of those questions that we are getting asked a lot of questions about. Just to clarify that again, it comes down to that start date of that agreement, when it's been entered into, and what you can and cannot be charging. So again, the new rules is after the 3rd of September commencement
Correct.
date. Can the reletting cost calculator for the RTA's website be used for leases entered into before the 3rd of September?
In a word, no, it cannot. So there, as I mentioned, the transitional period. So anything that was entered into prior to the 30th of September, this new way of calculating doesn't apply. So you'll find with the reletting calculator that it won't actually let you put a date in prior to the 30th of September 2024. So that would indicate that we go back to those reasonable costs in those circumstances, and that can, as I said, loss of rent, advertising, etc.
And can I charge the reletting cost as well as the rent payable for when a new tenant moves in? So that compensation for loss of rent and that reletting cost.
No, you can't. So for agreements that started after the 30th of September 2024, the amount chargeable to the outgoing tenant is the lower of the two amounts. So it's either rent from when the tenant left or broke the lease to when a new tenant moves in or starts the new agreement, or the amount as per the schedule. So let's say you've got a tenant on a 12-month lease and they end early within the first 3 months of the agreement. Now, the schedule says that they would be liable for the 4 weeks' rent. But if you go and re-tenant the premises within 2 weeks, then that's the maximum amount that you could charge the outgoing tenant. The difference between when the old tenant left and the new tenant started, and that would be 2 weeks.
Does an agent still have that duty to mitigate loss in a lease break situation? So we know that's in our legislation. So does that still apply?
Yeah, it certainly does. So a property manager or owner still must act reasonably in trying to find a new tenant for the property or room as soon as possible. So there's no change in that part of the legislation.
Okay, over to you to talk about utility bills and some other changes.
Thanks very much for that. So with regards to service or utility bills, such as water bills, the property manager or owner will need to provide the bill to the tenant within 4 weeks after they receive the document from the billing authority, unless there's a reasonable excuse. Now, if the tenant does not receive the documents within the required time frame, they don't have to pay. The thing here is that the tenant still has the same time frame to pay. So in water, for water bills, they still have 1 month to pay. And for any other type of bill, it should be noted on the tenancy agreement as to how they're going to recover those funds. Now, the key here, ensure that you note meter readings on both your entry and exit condition reports clearly and accurately if you wish to charge partial bill amounts to a tenant. And we all know that agreements don't always line up with your billing periods. So it's important that you've got those meter readings are documented correctly. Now, the other thing here is if you have a unit complex that receives one bill for multiple units, your 1 month starts when the bill is received from the supplier. If you need to read individual meters and calculate costs and issue bills to each tenanted unit, then you must ensure that those bills are issued to tenants within 1 month of the main bill being received. So some other changes in regards to that have occurred in 2024. So there's greater clarity on ending tenancies for short-term tenancy statements. Now that's for your movable dwelling parks. And also greater clarity around when a community title scheme is terminated. So there's been some changes to terminology regarding ending tenancies due to student entitlement, and also to the domestic and family violence legislation. And there's also been some expansion of confidentiality provisions around the DVF stuff as well. There's a new penalty provision for providing false and misleading information to the authority. And there's also been an update to the goods left behind process and a number of minor amendments, including increases of penalty provisions across the way. So.
Okay, so let's go back and have a talk about water and electricity bills. Can you charge a pro rata amount if the tenant leaves mid-billing cycle?
Yeah, you can. So the key here, as I mentioned, is it is important for your reading, the meter reading, to be on your entry condition report and also clearly stated on your exit condition report. So you can charge that pro rata amount, and it will, and it is important really that you show your tenant how you've calculated those charges.
Our next question, can I post on a tenant's Facebook page a photo of all their goods left behind and ask that they collect them?
Yeah, no, this probably not going to be appropriate. So in regards to the changes there, so let's look at what the legislation used to say. So previously, if the goods were left behind over $1,500 in value, you had to store them for 30 days, and then you had to advertise in a physical newspaper that you were going to auction them. So now the changes are that the process of public auction and newspaper advertising has been replaced with a more modern method. So we're not dealing with telegrams or faxes or paper newspapers anymore. We've actually moved a little bit into the 21st century. So you have a responsibility to contact the outgoing tenant, and you can do that now either by SMS, by email, by social media private message, not slapping a public picture up and posting it all over the place, by private message through social media. Or you can use obviously the emergency contact number from your tenancy agreement, or you can actually place a notice in an online newspaper now. So again, a little bit more modern ways and more practical ways of being able to contact the tenant, but no, not a public Facebook post.
And again, it's not about someone just being able to just dispose of goods and anything like that. There still is that other process, that items may still need to be stored and go through that process as such.
Yeah, absolutely. I'd really recommend having a look at the fact sheet that we have on our website around that process, and it does include all of that new information.
Does the abandoned goods limit still apply?
Yeah, it does, as I mentioned. So if in a general tenancy, if the goods left behind are $1,500 or more in value, then you've got to follow the process. And if it's a rooming accommodation agreement and the goods left behind are $600 or more, then you need to follow that process.
And what's the process what do we do if it happens that someone provides false misleading information to the RTA?
Yeah, this is a good question. So if false or misleading information is provided to the RTA, now an example of that might be where someone uses an incorrect end of tenancy date to be able to start the refund process before handover has occurred, or where someone might provide misleading information relating to a bond claim. So in those circumstances, and there are others, they're just a couple of examples, we'd advise the impacted party to submit an investigation request form. So this form's used to request us, the RTA, to investigate an alleged offence committed under Queensland rental laws.
Excellent. Thanks, Mark. And does the tenant still have a month to pay a water bill?
Yeah, they certainly do. And I did mention that a moment ago. So if the water bill is passed on to the tenant within a month of being received by the property manager or the owner, then the tenant has 1 month to pay the bill. Now, when it comes to other utility bills, as I said earlier, please ensure that your tenancy agreement contains information about calculating and payment of bills.
Excellent. Well, thanks for stepping through what we know has been quite a few changes during 2024. What we're going to now have a look at is a quick look at the changes that's going to happen on 1 May 2025. And again, we're going to have more detailed information about these changes as we get closer to 1 May. So, as of 1 May 2025, a manager or owner will need to disclose any benefits they receive from a tenant paying rent. So, note there is also penalty provisions for not disclosing what the costs are for a tenant to pay rent as well. So, for entry notice periods that are usually 24 hours, such as like routine maintenance, showing a prospective tenant or a prospective purchaser or valuation, that time frame will be increased up to 48 hours. There'll also be a limit on entry to a rental property once a notice to leave or notice of intention to leave has been issued. There'll be more privacy protections, and there'll also be a new standardised rental application form and guidelines on what information a manager or an owner can request from a prospective tenant. There'll also be a new form and process for a tenant requesting fixtures or structural changes. So, in a nutshell, there's new forms coming next year, as well as a focus on privacy and entry. So, when the legislation passed, there was also three heads of power to be established. Now, a head of power will allow for the creation of a future regulation. Now, this does have to occur within 2 years from the 6th of June 2024, meaning that a future regulation relating to a portable bond scheme, a code of conduct for the rental sector, and also modifications around safety, security, or accessibility. At this stage, we do not have any further update on those particular regulations. So, while we're talking about the changes that happened during 2024, it's a timely reminder that minimum housing standards is now in play for all tenancies. Rental properties need to be safe and secure, so that's your waterproof, structurally sound, in good repair, free of vermin, damp, and mould, have functioning lateral locks fitted to external doors and windows, and also window coverings. And it also needs to meet reasonable functionality components as well. So please do jump on our website for more information in relation to minimum housing standards. Now we've gone through a bit of a snapshot of an overview of 2024 changes. Now, the RTA has a lot more information and educational resources on these topics on our website. So, we also encourage everyone to ensure that they do use the latest RTA forms, which can be downloaded from our website. Remember, we are here to help everyone in the rental sector navigate these tenancy law changes. So please reach out to our fantastic team in our call centre on 1300 366 311 or jump online, have a look at the RTA's website. We have great resources there and we've got videos, podcasts, fact sheets, and publications. We also have a list of frequently asked questions that you may find will actually assist you as well. Thanks, Mark, for joining me this morning as we step through a bit of an overview of what today's or this year's changes has been, and also answering some of those questions that we have recently been receiving as well.
Thanks, Lynn. Hopefully that's provided some information for all of our listeners out there.
Thanks, Mark, and thanks for clarifying some of the changes as well with me. The webinar will now end. Thanks, everybody.